Good afternoon, everyone. This is Michael Strom from Oasis Senior Advisors, and today we're continuing our series on interviewing senior professionals. And today we have Jennifer Medeiros, an attorney who practices trust, probate, and
estate law.
So Jennifer, good afternoon.
Good afternoon.
How are you today?
I'm well, thank you.
Good. Thank you for joining us.
Thank you for having me.
Great. So I was wondering if you could start off by telling us a little bit about your background.
Sure, I'd love to. So I am an estate planning, probate, and trust lawyer. That means I draft wills, trusts, powers of attorney, advanced healthcare directives. I handle trust amendments for people that already have their trusts in place. Trust amendments, as well as handle trust administration. So for people that have trusts and the decedent has passed, I administer the trust for the family to make sure that the assets are distributed to the appropriate people. I've been doing this for nearly 15 years, and in the past I have taught classes on estate planning and probate to community college students who are studying to be paralegals. I have a lot of experience with clients over the last 15 years in drafting these documents and in counseling clients with this type of law, and I really enjoy working with seniors.
Okay, well, thank you, Jennifer. Well, could you tell us a little bit more about the different areas of law that you practice?
Yes, I can. In addition to the estate planning aspects, I also handle probate. Probate is a legal procedure that is ordered by court when a valid trust is not in place. Probate is where you're asking a court of law to issue an order distributing property to specific people. If you have a will, then your will designate who will get your assets. If you die intestate or without a will, the court will decide who gets your assets. So I also handle that procedure and guide families through the court process to make sure that the estates are completely distributed. That process can be very lengthy and, most importantly, expensive. That is the biggest reason why people tend to want to have trusts in place to avoid probate and the costs and the time associated with probate.
Well, thank you, Jennifer. Now, if you wouldn't mind, could you tell us a little bit about probate and the costs involved with it and why clients want to avoid that?
Sure, let's talk about that. So I have a graphic that I'd like to share, and hopefully we can have this be present on the screen. But for an estate that is worth about $1 million, that might be your house has a value of maybe $750,000 or $800,000. You might have some furniture, furnishings, clothing, jewelry, and some money in the bank. All of that totaling up to about $1 million. The cost of probate is $46,000, and that does not include the court costs. So you would need to estimate about another $3,000 or $4,000 just in court costs. So on $1 million estate, that is probate costs of about $50,000. You do not get to deduct the amount of loan that you have on your mortgage. So even if your house is worth $750,000 and you've got a loan of $500,000, the court still looks at the value of the house as $750,000. So a typical Orange County estate, expect to pay about $50,000 in probate costs. That's money that your heirs will not be receiving. It gets paid to the attorneys, to court, to appraisers, newspaper publication fees, county recorder fees. So it can be quite expensive. So probate fees are actually statutory fees. They're not set by me or any other attorney. They're set by the California Probate Code. So if your estate is worth less than $1 million, then the probate costs are going to be less. And on the other hand, if your estate is more, probate costs will be more. So the statutory fee for, say, a $300,000 estate is about $18,000. But if you have a $5 million estate, the cost of probate raises to about $126,000. And then again, you have to add the court costs on top of that. So there is quite a range, but it is based on the value of your estate. So if you factor in the cost of completing a trust, as opposed to the cost of probate, a trust might cost you between $2,000 or $3,000 to have a reputable attorney educate you and guide you through a trust process and a full estate plan, and you look at the cost of probate, that $3,000 you might be spending as opposed to $126,000 is really quite cost effective and a smart idea for seniors and anyone to consider.
Well, thank you, Jennifer, for that very interesting information. I appreciate that. And could you now, if you wouldn't mind, tell us a little bit more about wills or trusts? Which is right for your clients?
Okay, yeah, let's discuss that.
Great.
So I have a postcard here that I print out for my clients, and I'd like to share it on this video if possible. And this outlines one of the most common questions I get asked from clients is, do I need a will? Do I need a trust? Or what if I just die and have nothing in place at all? What's going to be the effect of that? And this postcard outlines the results of each of those choices. So if you were to die with a will, you can decide who's going to handle your affairs when you die. That's your executor. You can also decide who's going to receive your assets. Those are your beneficiaries. But if you die with nothing in place at all, then the government decides who your executor is going to be. They appoint an administrator in the probate process. And if you haven't told the court who you want to receive your assets in a will, then the court is also going to decide who gets your home, your car, your personal property, all the things that we acquire over a lifetime. You won't have any control over where those things go. So there is a law called intestate succession, and the court follows that, and they give your assets to the people that fall under the California Probate Code for intestate succession. If you die with a trust, you get to control who your trustee is. So that's who's in charge of handling your assets after death. If you become incapacitated, you get to control who's going to handle things while you're still living, but you need someone else to manage those affairs for you. You also get to control who receives your assets. Most importantly, and the thing that many people forget, is a trust is a private matter. So your will not be public, like in the news, Prince's will is, rather, he died without a will, so his estate is very public right now. So a trust is going to make that a private matter. So many clients wish to have their assets be kept quiet, and they don't want to have it be made public as to who's going to receive what or who might be disinherited. So there are many benefits to having a trust in place, and I am open to talking with any seniors that have questions about that and would like some more guidance on whether a will or a trust is best for them.
Thank you, Jennifer. Now, could you tell us a little bit about what advice you might have for seniors and their families?
Sure. There are some really common questions that I'd like to talk about.
Excellent.
I often get asked if a client should name their child, their son or daughter, on their bank account. In the event they become incapacitated, they want their son, for example, to be able to pay their bills. I advise against this. The best way to handle this matter is to have a durable power of attorney for financial affairs in place. That puts you in charge of your money for as long as you're able to handle it. And then your son can step in and pay your bills in the event that you're unable to. So you keep in control of your money, your name stays on your bank account, your son only steps in at the point that you're unable to handle your own affairs. You have the right to revoke that document at any time. So if you want to name someone else in place, maybe son moves away, you have another family member that's closer, you have the ability to change that. But I believe that it is a mistake to name your child on your bank accounts. Any creditors that they have can come after your bank account. Any accident they may have that's not covered by insurance, your home could perhaps be liened for an accident. So a durable power of attorney is imperative for every senior citizen to have, and any person over the age of 18 to have. A second essential document for seniors to have in place is the Advanced Healthcare Directive. Some people call this a living will. There are some other names, but an Advanced Healthcare Directive is going to include questions like, do I want to be buried or cremated? Do I want to donate anatomical body parts on my death? Do I want life support? What are my end-of-life decisions? Do I want to grant my agent the power to have an autopsy done if they think that there was some malpractice in the nursing home I was in, or if there was some negligence by hospital staff or a care person. So having these powers of attorney in place, this power of attorney for healthcare, is going to allow you to name an agent who can speak for you in the event you can no longer communicate with doctors or nurses. So you should nominate a person that you trust who understands what your wishes are for healthcare, and they can enforce them for you at the time that you cannot do it yourself.
Well, Jennifer, thank you for that information. So now, could you also tell us if seniors or their families are looking for legal assistance like the types that you offer, could you tell us how you differentiate yourself possibly from other attorneys that practice in this field?
Sure, I'd love to.
Great.
As I've been practicing almost 15 years, I've decided to focus my practice on justice area, estate planning, probate, and trust work. So that means that my attention is not going to be diverted to many other areas of law. Any educational classes that I have, they are focused on this area. I keep up to date on the latest seminars. I'm a member of Wealth Council, which has very progressive estate planning drafting tools, and constant MCLE, which is continuing education work with regard to this area of law. I also offer my clients a private client portal. So when they have signed their documents, I post their documents online so they have access to their healthcare directives. If they have an emergency, if they're on vacation out of town, those documents are privately accessed by them over the internet 24/7. And finally, I offer my clients a free consultation. So if any of your seniors would like a review of the estate planning documents they have in place or want to talk about having some established, I'd be happy to meet with them.
Well, thank you, Jennifer. If you wouldn't mind now, if you could just share a little bit with us, if clients would like to get in touch with you, what's the best way to get in contact with you?
Let me give you that info. My office is located in San Clemente, so I can handle probate court activities in Orange County or San Bernardino County. For estate planning, I can assist clients anywhere throughout the state of California in drafting their wills, trusts, or powers of attorney or trust amendments. My website can be located at www.genmedlaw.com. That's JENMEDLAW.com. My phone number is 949-420-0025. I look forward to meeting with you.
Well, thank you, Jennifer. Appreciate the time. Thank you, everybody, for joining us.